Welcome to the next topic of legal and regulatory issues. Legal and regulatory issues, these oversights a wide range of topics depending on the context. Here we will try to understand which relates to the businesses and individual, um, which normally these can encounter. At first, we will cover some laws important as an IT security professional. But before that, we will try to understand what laws are. Laws are basically rules and regulations created and enforced by governing bodies to maintain order, protect rights and liberties, and ensure justice within a society. They provide a structured framework for behavior, outline consequences for violence, and establish the authority and procedure for resolving disputes. There are several laws, although there are many of them. We'll cover only few of them over here, which relates to us. Starting with criminal law. Criminal law regulates offences against the state or public. These can be such as theft, assault, and murder. Here, society is the victim, and proof must be beyond a reasonable doubt. Consequences can be incarceration, death, and financial fines to punish and deter. After which we have civil law, which is also called as tort law. Here, individuals, groups, or organizations are the victims, and proof must be majority of the proof. Over here, you'll find financial fines, which compensates to the victim. This is we are talking as per IT security professionals. Okay. Then we have administrative law, which are also called as regulatory law. This regulates the activities of administrative agency of government, um, such as FDA, HIPAA, FFA law, etc. Then we have private regulations. Here, compliance is required by contract. This can be, for instance, such as PCI DSS. Um, if you are an card processing, if you want to contact a card processing information, then PCI DSS by regulation is a must. So that is why it is a private regulation. Then we have a customary law, which mostly handles personal conduct and patterns of behavior, and it is founded in tradition and custom of the area or region. This basically mainly addresses the personal conduct and uses a regional tradition and custom as the foundation of the law of that area or region, whatever. Then we have religious law. This is based on the religious belief in that country or area. They often include a code of ethics and moralities which are required to be upheld. These laws are derived from religious belief and addresses an individual's religious responsibilities. Last one, which is a mixed law. This uses two or more legal systems. We hardly find some anywhere, but it is still there. This is just for understanding. We are basically concerned with all the five laws which are above that mixed law. This is just for your information. That is mixed law also is there. Hi, welcome back. Uh, Here we will start with legal and regulatory issues. Legal and regulatory issues can encompass a wide range of topics depending on the context. Here we will try to understand some common areas where businesses and individuals often encounter legal and regulatory challenges. Despite the compliance, intellectual property, contracts, consumer protection, employment law, health and safety, environmental regulation, antitrust and competition law, data protection and privacy, litigation and dispute resolution, regulatory investigations. Responding to these inquiries and investigations by regulatory authorities such as SEC, FTC, or FDA regarding compliance with regulations. So it is crucial for businesses and individuals to stay informed about relevant laws and regulations and seek legal advice when necessary to ensure compliance and avoid legal issues. So this brings us to liability. So we, at the most, we have liability because when we consider as an organization, there will be someone who will be liable. So liability. So liability refers to the legal obligation or responsibility for something such as debt or wrongdoing. It can arise from various sources, including contracts, torts, that is tort laws, which are civil wrongs, and statutory laws. It determines who is responsible for compensating for harm or loss caused to others. It is essential for individuals and organizations to understand their potential liabilities and take steps to mitigate risk. Right. So this brings us to what should we do. So what should be the next step? So next step would be due care and due diligence. Due care and due diligence are two related but distinct concepts often used in a legal and business context. Due care can refer to responsibility of an individual or entity to act with caution and prudence. The key word is prudence in a particular situation. It involves taking reasonable steps to prevent harm to others or to protect one's own interest. The precaution that a reasonable and competent person would take in a given situation. This is what the keyword is. Reasonable and competent person. This is a keyword. So let's understand this by an example. Suppose a company is there and this company stores sensitive customer data, including personal and financial information on its servers. To exercise due care, the company in protecting the data, the company takes some of the steps such as regular security audits, access controls, data encryption, employee training, incident response plan. So by taking these steps, the company demonstrates due care in its safeguarding its IT systems and data, which reduces the risk of security breaches and protecting the privacy of its customer. So this has been taken care of. I mean, you should do what you have to do. So due diligence. This brings us to due diligence. Due diligence is more comprehensive concept that involves taking reasonable steps to investigate and evaluate a situation or potential transaction before making a decision. It is often used in a business context such as mergers and acquisitions to ensure that all relevant information is considered. So how do we do that? So the process would be systematically evaluating information to identify vulnerabilities, threats, and issues relating to organization's overall risk. So here what you do, you actually evaluate the things. I mean, you do a thorough investigation. Let's take a small examples. I mean, before acquiring a company, a buyer conducts due diligence on its part to review the company's financial records, legal contracts, and other relevant information to assess the risk and benefit of the acquisition. A company is considering adopting a new cloud service provider to store and manage its data. So before making any decisions to this new CSP, that is cloud service provider, the company conducts due diligence to access the security of the cloud service provider's infrastructure and practices. So what they do security assessment, they do compliance, they ask for data backup, third party audits, they do something like that. So by conducting due diligence, the company can make an informed decision. Now when they do that, they have an informed decision about whether they uh, the cloud service provider meets its security requirements and can be trusted to handle its data securely. So, all in all, in summary, due care is about the level of caution and prudence one should exercise in a specific situation, while the due diligence is a broader concept that involves thorough investigation and evaluation before making a decision. So, this brings us to the next topic of negligence, which is actually opposite of due care. Due care, you do all what you have to do. Now, in negligence, what uh, you don't do anything. So the failure of an organization to exercise reasonable care in safeguarding its information systems and data, which can result in harm or loss. So let's say, take an example. A company stores customers data on its server. Now, without implementing any basic security measures such as firewall, encryption, or access control, so due to this, what can happen? The company's server are easily accessed by unauthorized individual, which leads to data breach. In this scenario, the company may be considered negligent in its IT security practice because it failed to take the reasonable steps to protect the sensitive data of its customer. So negligence have the serious consequences. These consequences can be data breaches, compliance violence, loss of trust, something like that. Next topic of evidence. So here we will try to understand what are the different types of evidences we have to take in consideration in the context of law and investigation. Evidences can be classified into several types based on its nature and source. So it is very important how you obtain and handle the evidence. Based on this, the court of law can accept and reject your evidences. So what we should do about it? So what are the types of evidences which are there, and whether there are any exception to anything or not? We'll see that. So first is real evidence. Now real evidence, these are actually consists of physical objects or exhibits that are relevant to case, maybe such as weapons, drugs, or stolen properties. These are actually tangibles, which you can touch. You can touch and feel. Maybe your laptop, maybe your mouse. These are tangible objects. So these are real evidences. Then we have direct evidences. Direct evidence is based on personal knowledge or observation and directly proves a fact without the need for inference. Now, what is direct evidence is this evidence you can uh, sense it sense with your five senses. I mean, you can see, you can touch, you can feel. So these are direct evidences. For example, you can see an eyewitness account of a crime is considered direct evidence. This is also called as first hand witness. So if you get anything in your case question such as first hand witness or direct evidence, so they won't ask. They'll give you something like first hand witness. So it means direct evidence. Then we have circumstantial evidence. The circumstantial evidence itself means that based on the circumstances. So circumstantial evidence is indirect evidence that implies a fact but does not directly proves it. For example, maybe your fingerprint found at a crime scene, or maybe your nails. So these are circumstantial but not a direct. Then we have corroborative evidences. Now, this evidence supports or confirms the truth or accuracy of other evidence presented in a court. Corroborative evidence is used to strengthen the credibility of a particular piece of evidence or testimony. That means you already have the evidence, but corroborative evidence is just attaches to it, and it enhances the evidence which you have for which it has been presented. So corroborative evidence is particularly important in case where the primary evidence may be questioned or challenged. So there are certain types of uh, corroborative evidences uh, available, such as, I mean, differentiated. These are physical evidence documentary evidence, testimonial evidence, digital evidence, documentary evidence. So physical evidence such as fingerprints, DNA, or other forensic evidence that supports a witness's testimony or other evidences presented in the case. Then we have documentary evidences such as records, contracts, or other documents that supports the claim made by witness or party in a case. Testimonial evidence, testimony from additional witnesses who provide similar accounts of events or circumstances. Then we have electronic evidence, which are actually also called as digital evidence. These are such as emails, texts, or social media posts that supports or confirms other evidence presented in a court. So corroborative evidence is often used to build a stronger case and increase the likelihood of a favorable outcome in a legal proceeding. However, it is important to note that the corroborative evidences should not be confused with conclusive evidence, as corroborative evidence simply strengthens the existing evidence but does not necessarily prove a fact beyond a reasonable doubt, right? So each type of evidence has its own rules and requirements for admissibility in court, which may vary depending on the circumstances of the case. This brings us to hearsay. So hearsay, if you'll bifurcate or if you'll just break the word here, that means you are hearing something and then you are saying that. This is also called as no first hand proof, right? So hearsay is a term used in law for to describe an out of court statement offered in court as evidence to prove the truth of the matter asserted in this statement. In a simpler term, hearsay is when someone says in court that they heard someone else say outside of the court to prove that what was said is true. That means if I am a hearsay, I state to the court that I have heard this statement outside of the court and this person was saying this. So that's why I become the hearsay. Now, hearsay is generally not admissible in court because it is considered unreliable. The rationale behind this rule is that the original statement was not made under oath in court, and the person who made the statement is not present in court to be cross-examined about the statement's accuracy or truthfulness. Right? There are, however, exceptions to the hearsay rule. Uh, for example, now this rule is 803 Federal Law of 803. For example, if an organization detects unauthorized access to its network and finds log entries showing a particular IP address accessing sensitive data, this direct evidence would be analogous to direct evidence in legal context. If, in addition to this, the organization also receives a report from third-party security vendor indicating that the same IP address has been associated with known malicious activity, this could be seen as corroborative evidence supporting the conclusion that the network beast was malicious. Okay, so this right exception to hearsay also. So it is not that it won't be accepted. It depends on the court of the law how the evidence has been presented. This brings us to the we have seen the types of the evidence. Now we'll see uh, rule of the evidence. So what are the rules of the evidence? So there are some rules of the evidence. We have best evidence rule. Now best evidence rule is based on the idea that digital evidence, like any other type of evidence, should be presented in its original form to provide potential issues of tampering, alteration, or manipulation. Evidence should be accurate, complete, relevant, authentic, and convincing. Right. This means that if a party wants to introduce an email or other electronic document as evidence, they should ideally produce the original digital file containing the message rather than the printed copy or a screenshot. So overall, the best evidence rule in IT security emphasizes the importance of maintaining the chain of custody and ensuring the integrity of digital evidence presented in the court. This brings us to the secondary evidence rule. Now, what secondary evidence rule says? The secondary evidence rule allows for the use of copies or duplicates of original documents as evidence when the original documents are not available, may be lost or destroyed, provided certain conditions are met. These conditions may be a satisfactory explanation for the unavailability should be there. Proof of the existence should be there. Execution or occurrence of the original document should be there, showing that the copy is a true and accurate representation of the original document. In the context of IT security and digital evidence, the secondary evidence rule could apply when the original document or original digital file is unavailable or can't be produced in case, court. For example, if the original email containing crucial evidence is lost due to system failure, or a copy of the email stored in the backup system might be admissible under the secondary rule evidence. So this brings us to evidence integrity. So evidence integrity refers to the state of being whole, unaltered, and trustworthiness. So how will no, this is just based on the first two rules of the evidence. It should be best, the best rule evidence which is complete, relevant, authentic, and convincing. So what makes that uh, uh, evidence best evidence rule is evidence integrity. So evidence integrity refers to the state of being whole, unaltered, and trustworthy. Now to for the digital evidence in IT security, evidence security is crucial for ensuring that the evidence accurately represents the original data and has not been tampered with or altered in any way. So how we do that? We use digital signatures, we use hashes, we secure storages, storing digital evidence in a secure manner to prevent unauthorized access, tampering, or loss. Then we use using forensic tools and techniques to analyze digital evidence in a way that preserves its integrity. So these are some of the evidence integrity rule which we need to follow. By following these principles and practice, investigators can ensure the integrity of digital evidence and enhance its reliability and admissibility in the court. This brings us to the chain of custody. Now, what is chain of custody? So, for digital evidence integrity to occur, we need to have chain of custody. So, you can see how from bottom we are moving towards up. So, chain of custody is establishing and documenting a chain of custody for the evidence which tracks the possession, handling, and transfer of the evidence from the time it is collected until it is presented in court. This helps ensure that the evidence is not tampered with or altered during handling. How will you do that? So, chain of custody. So, how do you maintain that? You maintain detailed documentation of the evidence collection, handling, and an analysis process. This document should include information about who collected the evidence, when it was collected, where it was collected, and how it was handled and analyzed. This brings us to reasonable searches. So, reasonable searches refers to searches conducted by law enforcement or other authorities that are considered reasonable under the law. The concept of reasonable search is based on the Fourth Amendment to the United States Constitution, which protects individuals from unreasonable searches and seizures by the government. A reasonable search is one that is conducted based on a warrant issued by a judge or under circumstances where a warrant is not required, but the search is still considered. In a general, a search is considered reasonable if it is based on a probable cause and conducted in a manner that is not overly intrusive and invasive. So there are certain factors which is considered in determining whether a search is reasonable or not, which includes probable causes. This is typically established through a sworn statement or affidavit presented to a judge to obtain a search warrant. Then scope of the search. The search would be limited in scope to the areas or items specified in the warrant or justified by the circumstances. Manner of the search. Manner of the search. I mean, it should not be overly intrusive or invasive. For example, authorities must knock and announce their presence before entering a house to execute a search warrant, unless there is an exigent circumstances. So now exigent circumstances, which is immediate threat to human life or destruction of the evidence. This is where your Fourth Amendment won't work. So please remember that in this condition, in this circumstances, your Fourth Amendment won't work. So overall, the reasonableness of a search is determined based on the specific circumstances of each case, taking into account the Fourth Amendment's protection against unreasonable searches and seizures. Conducting reasonable search in an organization requires balancing the organization's legitimate interest with respect for employees' rights and privacy. Clear policies and communications and adherence to legal and ethical standards are key to ensuring that searches are conducted in a fair and reasonable manner. For organization, in the case of organization, you should let your employees know that what you are doing. I mean, they can be searched if anything goes wrong. Okay, this brings us to the next topic of entrapment and enticement. Entrapment and enticement are tactics that may be used to catch or deter individuals engaged in illegal or unauthorized activities. While these tactics can be effective in certain situations, they raise ethical and legal concern also. Right? Let's see how entrapment. Entrapment, it is illegal and unethical. So what you do when someone persuades an individual to commit a crime that they would not have otherwise committed. So you entrap someone so that they should do some crime. That is what it means, entrapment. You trap that. It is illegal as well as unethical. And then come the entrapment, enticement. Enticement, here you lure or tempt individual into engaging in illegal activities by offering them incentive or opportunity that they find appealing. So what happens over here? I mean, someone has already committed a crime. I mean, someone has already broken the law, or at least have decided to do so. You are just only luring them or tempting them to do something more. So honeypots are the basically best example for this. But still, entrapment and enticement can be used to catch individual engaged in illegal activities. They raise ethical concern about the use of deceptions and manipulation. Additionally, in many jurisdictions, entrapment is considered illegal and may lead to the dismissal of criminal charges if it is can be proven that the individual was entrapped. In the context of IT security, organization should be cautious about using entrapment or enticement tactics and should ensure that their action comply with legal and ethical standards always. It is important to focus on proactive measures such as implementing strong security measures and educating users about the risk of engaging in illegal activities rather than relying on deceptive tactics to catch potential offenders. Right. This brings us to the next topic, intellectual properties. Intellectual properties refers to creation of the mind, such as inventions, literary and artistic works, designs, symbols, names, and images used in commerce. Intellectual property is protected by law through patents, copyrights, trademarks, and trade secrets, which gives creator and owner certain rights over their creation. These rights enable creators and owners to benefit financially from their creation and to protect them from unauthorized use by others. So we'll start with patents. So patents grant inventors the exclusive right to use, make, sell, and distribute their invention for the limited period of time. This is usually 20 years from the date of filing of the patent application. Patents need to be novel. It should be useful, and it should not be obvious. These are the three criteria in patents. How it works is, after the inventor completes an application for patents and it is approved, the patent grants a limited property rights to exclude others from making, using, or selling the invention for a specific period of time. For example, when a pharmaceutical company develops a specific drugs and acquires a patent for it, that drug is the only one that can manufacture and sell this. I mean, that company is the only one that can manufacture and sell this drug until the stated year in which the patent is up, and up means the patent has expired. Usually this is 20 years from the date of approval. So after that, the information is now public. So when information is public, enabling all companies to manufacture and sell this product, which is why the piece of the drug, price of the drug drops substantially after its patent expires, and generic version hits the market. The patent process also applies to algorithm in the same way. If an inventor of an algorithm acquires a patent, she has a full control over who can use the algorithm in their product. If the inventor lets vendor incorporate the algorithm, she will most likely get a fee, and probably a license fee on each instance of the product that is sold. Right? That's a good thing. We move on to copyrights. Copyrights protect original literally artistic, musical, or other creative works fixed in a tangible medium of expression. So copyright owners have the exclusive rights to reproduce, distribute, perform, display, or license their work. Copyright protection gives the creator or owner of the work the exclusive right to reproduce, distribute, perform, display, and create derivative works based on their original work. This means that unauthorized copying, distribution, or use of copyrighted works without permission may constitute copyright infringement. Now, copyright, there is also a protection to the copyright. Copyright protection generally lasts for 70 years after the death of the author, or if the work was work for hire, which is a corporate thing, or a corporate, then copyright persists for 95 years after the creation. This brings us to trademarks. Trademarks are used to protect words, phrases, symbols, or design that distinguish the source of goods or service. Trademark owners can prevent others from using confusingly similar mark. That means you might have seen counterfeit. We have Rolex watches. The counterfeiting of that, the counterfeiting of, there are some brands who almost put Rolex kind of logos in their watches to sell them as a Rolex brand. So that is actually trademark which they are using, but they change that. That is a counterfeiting. So trademarks get counterfeited. You have counterfeiting over in the trademarks. Remember this. Nike shoes are there. The right sign or the wordings which are written in Nike, Reebok. So these are actually the words, the phrases, or the symbols, or the design which is being used by these companies, or many of the companies are there. So that is the trademarks. Now we come down to trade secrets. Now, trade secrets are valuable information that is not generally known or is subject to reasonable effort to maintain is secrecy. So, in short, what it means, trademark is something kept secret. If you don't tell a secret, if you don't tell your secret, nobody knows. Once you tell your secret, then it is all, the game is over, then everybody knows this, you don't get then any protection for trade secrets. Then there's a last thing, just a small introduction. We also have industrial design, which protects the visual design of objects that are not purely functional, such as the shape or surface on ornamentation of a product. This is just a new thing, not very much sure about it. It is not related to the exams, but just wanted to highlight that we also have industrial, something called as industrial designs, which has came up. This brings us, I'll see you in the next. Bye.